Welcome to the Dish on Divorce. I'm Leanne Townsend.
And I'm Jennifer Barkin.
And on today's episode, we're going to be talking about the do's and don'ts of divorce. And we have a special guest. She's a family law lawyer, and her name is Ida Mirzadeh. Did I pronounce that correctly?
Yes, you got it good.
Okay, perfect. So welcome to the show, Ida.
Thank you so much. Thank you for having me. And I'm so excited to be here, out of our homes and in person.
Well, it's so nice. I know we've chatted on social media, and we've been on, you've been on my podcast, and we did a marketing episode on your show.
Right.
So it's nice. It's always nice to meet in person.
Right. I know, for sure. And even though, with that being said, sometimes I feel like even talking on social media or Zoom, you do kind of feel like you're getting to know the person, but it is for sure nice to, I feel like I already knew you. Even
yeah, likewise.
This is the first time we're meeting.
You look exactly how you look on social media.
Good.
So there's no.
I thought you knew each other.
Just from social media.
Yeah,
talking.
never in person. We didn't meet in person.
Okay. So it's nice.
Yeah. So why don't you start by telling listeners a little bit about your practice and the type of work you do?
Okay, so I'm a family law lawyer, as you mentioned. I am a Farsi-speaking lawyer, one of the only family law lawyers in Peel that provides that service. So I can, service my clients in Farsi, which is good. I pretty much do all areas of family law. We do litigation, alternative dispute resolution. I think what kind of sets me apart is that I really do try to focus on, the high conflict parenting cases, the property cases, but I don't believe that, they all belong in court. I do like to take, a different approach in the way I am trying to really find out what are you exactly looking to get. It's because I don't think it's a, one thing fits all. I try to really break it down and say, well, what I'm hearing from you is you just want to be done. And sometimes when you just want to be done, court is the last place you want to go. So I really take that approach. And I think, in the last couple of years, especially, it's really helped set me apart from other family law lawyers.
I think it's really important when I work with clients, and I'm one of the rare mediators, I think, who actually says to their clients that you really should get some legal advice. I can't make you.
Right.
But you're negotiating, and I can advise you on the law.
Right.
So it's a great idea before mediation to seek some legal advice, any point during mediation to get some legal advice. Am I making good decision, right?
Right.
Is this good for me? And at the end, before anything is going to go into an agreement of any kind. But funny, a lot of people who do go to mediation say we want to avoid lawyers, and I don't think that's a good idea.
I know, and that's a big thing that, for me also in the last year through the pandemic that I'm trying to kind of achieve just through my networking and my growth on social media. And Leanne, I know you do this a lot too. I'm just trying to kind of create a community for people that are going through this difficult divorce situation, and also show that we're not all bad. Not all family law lawyers are just here to line our pockets. We are here to help people at the end of the day. And I agree with you 100%. Legal advice and having proper legal advice before you even decide to take the step of proceeding with a divorce or filing a court application. I think it's so important to have, get professional advice and a lawyer's advice for sure.
For sure. I mean, I think it sets people, they can make a decision that they don't know the long-term consequences of, even with respect to children, setting up a status quo that they didn't understand could come back to really hurt them, but they didn't get legal advice to understand or know that. What do you find, in terms of if you were to have a new client, and what would you say are the top 5 do's of divorce that you would advise a client?
Yeah, so I think the biggest thing that happens when they come to me is I find that they're focusing a lot on the little pettiness and the drama of divorce, which, and to their credit, it's because they're going through the emotion and they're just, it might be the worst possible thing in their mind. But then when they actually say it to us as professionals, we're like, that doesn't actually really matter, or it doesn't help you. So what I like to do is I try to get them to focus on, not the pettiness. And I say, I understand you're going through this, but my job is to kind of separate all that at the end of the day, I'm not your therapist, but I will try to, if they need to vent, I will let them do it. You know what I mean? Because then maybe they just need to, I'd rather them do it to me than, for example, go post on social media, which, you know, that's like something that I saw you just did a blog about, but that's another one of my big mistakes that people do is they put a lot of negative energy and whatnot on their social media or just putting it on, you know, the internet, which can always come back and bite you. So I always say, you know, if you got to vent or whatever you got to do, say it to a friend, say it to a family member. But what I try to do is separate, like I said, all that nastiness, the pettiness, and turn it into something that can actually help create a solution. You know, a lot of times I even see lawyers are putting just really nasty things in an affidavit, which is a sworn document. And it's just, I'm reading it and that's not my style. Don't get me wrong, I can take a strong position, but I think there's a difference between advocating strongly and firmly and having the law behind you and what you're saying than just throwing in ridiculous accusations that are not even, they're not substantiated. They're not child focused. If it's a parenting case, I find that happens a lot. And sometimes our clients come to us and they want us to do that. Mm-hmm. You know, they tell us flat out, you need to be really strong. You need to put them in their place. And I say, okay, but why do you want to go down that? Number one, it's extremely expensive because writing affidavit after affidavit and, you know, bringing all the motions in that you need that are not really necessary, what is that going to achieve for you? And sometimes they're very honest with me. They'll say, well, I want them to suffer. I want them to.
Yeah, they want to piss them off.
I want to piss them off.
And I find that's one of the biggest challenges I find as a lawyer is when if the other side is putting that kind of material before the court, and when they go into court and they start off with all these things that are really not true or exaggerated, like I find it's hard because it's like they're down in the mud. And if you want to stay out of the mud, your client probably, it's like if someone's in the mud, unfortunately, I find you have to get in the mud too in order to combat it. And I hate that. Right. I absolutely hate it. But in my experience, like taking the higher ground, we're not going to do that. But the other side is, your client's not happy and it can influence the judge and towards the other side.
That's 100% true. And you know, sometimes the clients do tell us, you look weak or and then you lose that you open yourself up to, am I going to lose the file now?
Yeah.
Because they think I'm not. So I think at the end of the day, like you said, I think it's a fine line between how you can advocate. What I like to do is if my client is accusing the other side of something, I say, can you show me, prove it? I'm not just putting it in there if it's baseless. Like, it needs to help your case. And I'm very straightforward with my clients. I don't sugarcoat it. And and I do represent a lot of the payors or the ones that are paying the property settlement. And they, at the end of the day, it's a very tough position we're in because they're paying us. They're paying the other side, and it's very hard to manage their expectations. And so, after the part where they're yelling at me and they're like, I can't believe you're making me do this, they do really appreciate it because they think, you know what, I have friends that have been doing this for 5 years. They've spent so much money. You just told me to get to the point and we're done. I might have spent an extra $10,000 because you told me to pay her to go away, but at least I'm not spending it in legal fees in court and going through the stress of not knowing what's going to happen, right? But 100%, sometimes and sometimes as lawyers too, when we see that someone's acting that way, like the other side is saying things in an affidavit, we inherently want to react. We want to say, well, no, this is completely wrong. Sometimes I even find myself into emails, especially when I get emails from opposing counsel and it's overly aggressive. I'm writing back very aggressive. And I was like, okay, I'm not going to hit send though, because that's
So you're almost like your client who wants to send that nasty email to their spouse, where I would always say, write whatever you want. Just don't press send.
Exactly.
Because it can be therapeutic to do the writing.
Right. No, 100%.
Just don't send it.
And, another thing just going off of that is, I think a big mistake that people make is that they focus too much on, for example, and this is more for parenting cases, where they are constantly berating the other parent and sending nasty emails to them or saying you're a horrible dad or you're a horrible mom. And it's, sometimes the kids, they're either too young and they don't know what's going on and okay, maybe you can get away with it. But when they're at that age when they kind of know what's happening, they do feed off of a lot of the negative energy that's going around in the court process. And we always tell our clients, don't discuss the court case with your kids. Sometimes we even put it in agreements, like we will not. But at the end of the day, you might be having a conversation with your friend or your family member and they're hearing it or going back to the social media stuff, you're putting it out there. Your kids are one day going to see it. And I like to always tell my clients, they may be the worst person in the world. They might be the worst spouse in the world, but that doesn't mean they're a bad parent. And I always like to, take a step back and say, what about your child? Like, what do you think he or she thinks? Do you actually think they're sitting there saying, I hate my parent? Or, do they have joy and excitement when you talk about the other parent or seeing the other parent? Most of the time they say, no, they love their dad or they love their
even
mom.
if they're a bad parent, to be honest. Like I've said this to clients, like unless they're like negligent or abusive, like even if they're not, like even if one parent is way, way better of a parent, like the child still has a right to be spending time and having a good relationship and a joyful relationship with a bad parent,
Well, more frequently I see that the couple, they're so angry with one another. So she's a bad mother and he's a bad father. But often when you dig a little bit deeper, it's not that either one is bad. They just maybe have different views. They do things differently. One parent allows junk food a couple of nights a week and one parent wants all organic, but yet that person's a bad parent.
Right.
But I ask my clients and parents that I deal with to even look ahead.
Right.
Look ahead. What do you want this to look like?
Right.
Your kid's graduating high school, so hopefully it's not COVID. And they're coming off the stage. So is it nice to have, it's so icy, mom's over here, dad's over here, and the child doesn't know where to go.
Right.
Like, wouldn't it be nice if we can put on our big girl panties, or I don't even know what you say for a man, and just make this about your child.
Right.
Right? And the gift you're giving your kids is you don't have to like people, but you have to treat them decently, respectfully. And that's going to work for people, for your children, when they have a boss that they don't like.
Right. You're teaching your children by example.
Yeah.
Right.
Yeah, no, for sure. And I think, it's so important that we do that. But again, it's easier said than done when you're going through a divorce and you absolutely cannot stand the other parent. I feel like it's really hard. But like you were saying, they might not even be the most perfect parent, but at least I think, no one's given a manual of how to be a perfect parent. No one really knows what they're doing. But I think in time, the other parent will get confidence and feel that, I'm figuring it out, because that's what everyone always does. The primary parent always feels that they're the better parent because they're with the child the most, right? And the more you do something, the better you get at it. So I always tell my clients, because it's the same thing. They say, he doesn't, the biggest thing that comes up is, especially with smaller children, is the hygiene. Like they say they're not bathing them properly or, you know what I mean? So I always say, but because they're only with them one overnight every 2 weeks, So how are we going to encourage them to have more time? And now with the changes to the legislation, at least I think we'll see a little bit more of a equal kind of where we start from, because I think a lot of times people listen to what others say, or they say, my neighbor only does every other weekend, so I should do it every other weekend. And so I always say, well, no, let's just find what's best for you, and we can work our way. Because it might be that the other parent just doesn't have the time. It might be
they may have a work schedule that, or they travel a lot, for business,
or drop
like
off
that.
for schools. Maybe they just can't do it. So maybe we have to figure out a way to have more consistent time. Maybe not so many overnights, but we can, deal with the duration and the frequency. Also, it obviously affects. It depends on the age of the child. But I really work with them in a more. I try to make it so that it's more unique to each person, rather than saying,
everyone's getting every other weekend, and this is what we're doing.
So one of the things I notice, which, and I don't know, both of you come across this, is I find a lot of the moms take ownership in the children and seem to feel that they should be the one to decide how much time dad gets and that they should definitely get more time. And they get very frustrated because they'll say, I'm the one who always did everything and and I say to them, well, it doesn't, like, if dad wants to be a very involved father, it doesn't matter that when they were 2 years old, maybe he wasn't as involved, or 3 years old. Like, shouldn't you be happy for your children that dad wants to be this involved?
Right.
But it's these moms who feel like they own the children.
Except either way when it's about the money.
Yeah.
Right.
Because I can tell right away when somebody says, I want at least 60%.
Or like,
because I know that formula.
Yeah.
You know that formula.
No, I know.
And I'm like, okay, this has nothing to do with your child. So we're going to have to dig a little bit deeper.
Right.
And what's your work schedule? How far is the child's school?
Yeah.
What's this look like for you?
Sometimes I even just call their bluff, like talking on the reverse now, where sometimes the dads are the ones that are saying they want 49% or
bingo.
Yeah.
So then I say, well, this is about child support. And then I tell my client, if I'm acting for mom, I say, just call his bluff, let him have it. Just put it, because it's at this point we're in the stage of drafting the agreement, or we're trying to figure out what we're doing for the parenting time. So I say, you know what? Let's stop wasting time. He's saying he wants this much time. Let him have it, and let's see if he actually does it. So many times it's like, oh no, he can't do the Wednesday anymore because So then it's just like, okay, we'll see. So that was obviously not a child-focused thing at all. It was just you were concerned about your financials. And representing a lot of the payors, I understand that it's like, it is stressful, but at the end of the day, whether you're with your partner or not with the partner, kids are expensive. And I don't think a lot of times people understand that, and they think, well, I don't feel comfortable paying child support to the mom or to the parent because they're spending it on themselves or, and it's just like, well, you probably don't realize this because you're not with them enough. And that's why the child support formula is the way it is because there's lots of things like food, shelter, clothing, which are just basic needs that are expensive. And
trying to keep the household similar. Like you don't want, one parent's in like a humongous mansion with every, luxury and amenity, and the other person's, living in subsidized apartment, in a bad neighborhood. Right. Like that's not good for the children to go back and forth.
Yeah, some
parents really don't care.
Yeah,
about
I know, but that's the legislation about being child focused. It's the child support guidelines. Right. The part of the purpose of them is to prevent that from happening.
To balance out. That's why when you look at that divorce mate calculation, you're going to see they show you the percentages of income for each household.
Yeah.
Sometimes I even use because the spousal support is kind of secondary, and if I have a file where both of the child support and spousal support is on the table, and I'm representing the payer, I say, you know what, like, kind of getting on board more with paying child support and all the Section 7 expenses will also get you a little bit out. It may actually get you completely out of spousal support, but it will lower your basically net disposable income that you can spend on all these other additional things that your ex is asking for. And then when I say that, they're all on board. They're like, okay, so like what other Section 7 expense should I pay for? Because when you break it down for them and you say it is the right of the child, it is for your child, and don't you want them to have a good life even when they're not physically with you? You want them to enjoy, wearing clothes and going to their friends or whatever they're doing. So let's make it so that it's nice for everyone. And when I tell them like that, they're just like, oh, okay, yeah, that's true. And especially when they hear they might not have to pay spousal support because there's just not enough money to go around, they're like, oh, you know what? That's a good thing.
Spousal support is never the happy topic.
No. And I get it. Like I wouldn't want to pay spousal support to a guy that I'm, married to. I'll be honest. Like that would piss me off if I'm working really, really hard and he's not, and like I would have an issue with that. So I get when payors don't like that. I mean, you put yourself in a situation though where you're it's, you know, if your spouse has stayed home and raised children and gave up their career and you're benefiting in the home from all of that, then, you know, I think you do owe that person, you know, not just legally but morally or ethically, like to, you know, to compensate them in some way. But I think people, they do that, and then when they have to pay the spousal support, they're mad. So it's well, if you didn't want to pay it in the first place, you should have
sign a domestic contract. You know, I think that's the main thing when it comes to spousal support. If you want to make sure, you know, if you're planning for your future, and I think that's really the only way that you can really protect yourself. Obviously, child support, we can't contract out of child support, but yeah, with spousal support, I find it's so hard. It's such a hard topic, and if we're out of court and we're trying to resolve things, I find that a lot of people don't mind paying the lump sum. Like, they'd rather do it in a lump sum.
Yeah, clean break.
Exactly. And they can just, the way they kind of think about it in their head is just like, I'm done. And it is, you know, even though you don't get the tax deduction for it, as you would in the monthly support, I think it's just a way for them to feel.
And tell our viewers, because they're not going to know. So,
sorry. Okay.
Who gets the tax deductions?
Right. So if you're paying monthly support, you have to claim it on your taxes because it's like income. And if you're the payor,
for spousal only.
For spousal support, you can deduct it on your taxes. So sometimes the monthly support, which is if you're in court, a judge is most likely going to order you pay monthly support, not a lump sum support. The reason why I was saying that if it's out of court, it's because we as lawyers can get a little bit of creative with the way we do the formulas to figure out a lump sum amount. Our DivorceMate software actually tells us what it would be, taking into consideration the tax credit and deduction as well. The support calculations do. So it's not like if you're paying lump sum, you're actually getting no benefit. It's supposed to be worked in. And also it's a clean break. And after that, you can get them to sign a release, a spousal support release, meaning that it's forever final. They can no longer come back and ask you for support because there's no limitation on spousal support. You can actually ask for it even if you've been separated for 10 years. So it's really nice. It's really important sometimes and valuable to the support payor to have that spousal support release, just so that they can never have to worry about it again.
For sure. Because, yeah, nobody wants somebody coming back to them, you know, 6 years or 10 years down the road and wanting more money. You know, that's something a lot of people, I think, fear.
I recall a few years ago, though, seeing an article, is a final release ever really final?
Right.
Was there ever an issue with that, or some cases that tried to open up?
People can always bring something called a motion to change and say that there's been a material change in circumstance, and, you know, what if someone is disabled now?
Right.
You know, they entered into the release and everyone was fine. Maybe they were still healthy and could even work. So they thought, yeah, we'll sign the release because now everything's fine. But then, you know, you get into a terrible car accident, let's say, and you are disabled and you really would need maybe that extra support. You can still try to, you know, bring a motion to change, and you have to use that as your evidence, saying that at the time that we signed the agreement, this was not foreseeable that I was going to become disabled. But I think it also depends on how long ago was that. Like, it can't be 20 years later and you come back and you're like, oh, by the way. And also, like, if maybe you're at a different part in your life, maybe you have a spouse already. So you obviously can't be asking for spousal support from your ex. So I think with family law, it's like you can never say a final answer.
Yeah.
I
feel like there's always room
someone can always argue that something should be opened up and re-looked at, and, you know, and with children, of course, nothing is final. You know, that, and like, I guess until they're an adult and out of school or whatever. But yeah, there's always room to, you know, anyone can argue anything, I guess, if they want. But with
spousal, I would think a really well-written agreement would have provisions that both parties are aware that a catastrophe could happen.
Right.
That, you know, somebody could become desolate. They've obtained their independent legal advice. They're aware all of these things can happen. But once signed, this is a final release. And I think that would be harder to open up if I'm...
For sure. And I think, you know, a lot of times people overlook that part. They think like, oh, we signed it and it's witnessed and we did get independent legal advice, but it's not well drafted. Like, sometimes we see these agreements and, you know, now
kitchen table agreements.
Exactly. Now I feel like, you know, with all the advances in technology and our software and our divorce mate, I think that it's getting very advanced in the way that we're drafting. Like the only agreements that I see that are being challenged are ones that have been done years and years ago. Like I haven't really seen any recent ones being set aside, and the ones that are trying to be opened up or set aside are ones that were not drafted properly, either not by a family law lawyer, just like I've seen promissory notes trying to pass as separation agreements.
Yeah.
So if it meets all the credentials of a real, binding separation agreement. And another big thing is financial disclosure.
Yes.
When people don't do that, and that's another big don't when it comes to divorce. It's actually, something that people are shocked by when they have even a consultation with me, because I ask them for all this disclosure and they're just like, their backs up are against the wall. And I'm like, I understand completely your reaction. I get that it's very, invasive. Even when I'm getting a house and I go to the bank and I have to do a mortgage renewal or obtain a mortgage.
All the paperwork.
Oh, I even feel like, are you serious? Like they need every detail of your finances. And it's just like, now imagine you're going through a divorce and you're already spiteful and you can't deal with the other person, and now they're going to know everything.
It's like you're naked and now their lawyers know, and
Everyone
the law
knows.
clerk knows,
Yeah.
and this one knows.
Yeah.
And it's a lot
maybe
of
they
work.
speak to other people in the office, like this one, in this case, in this file,
Yeah.
and you just feel that you have no privacy.
Right. And what I try to explain, like I let them go through all those emotions and say, I can't believe you're asking me to do this. Because sometimes, for our viewers, we do go back 3 years, right? Just so that we can, especially if someone is self-employed and we can't really determine their actual income, we do sometimes need to go back 3 years or sometimes more.
Is there a law? Because I know I ask for 3 years of statements, but I've also seen where you have, because things are not making sense. So people will say, lawyers, 5 years.
Yeah.
But is there a law that says 3 years?
Well, 3 years is the rule of thumb.
Right.
Okay.
And to file an application or an answer, you need 3 years notice of assessments and 3 recent pay stubs. So I guess the 3-year rule of thumb came from how you have to attach 3 notice of assessments. So we just figure, okay, 3 years. But I have some where it's like 5 years. Sometimes people ask for 10 years, and it's just like the bank sometimes doesn't even have those records because it's usually 7 years. So I let them vent and say this is ridiculous, and I say I completely agree. But then they start talking about things like, oh, but I brought this into the marriage, or I did this, and how about all this stuff? And I say, exactly. So this is why we need to bring
financial disclosure.
Full disclosure.
Yeah.
The more you provide and the more you are organized, the less there is room for any type of, inferences to be drawn by a judge or by the other side, or by the other side to make up a story about this amazing life that you had. And now they want to ask you for support because of that lifestyle. But really, you were living beyond your means and you were in debt. So let's show that. Let's just provide as much disclosure as we can, that they just get sick of us and they say, okay, you proved your point. And I find that is so much more effective. Another don't is do not hide your assets, because it always comes to light of what you're doing. Or a lot of people try to start selling off things or, taking on loads of debt. And I think that's just That's
so obvious what you're doing.
It's so obvious. Or some people tell me flat out, oh, really? You said I have to pay that much child support? Well, I'm going to quit my job tomorrow. And it's just like, no, you're not. Because number one,
have income imputed.
Exactly. Like we're going to impute income to you. So and sometimes it's harsh that I literally have told my clients before in the past, I'm sorry, but maybe you need to get a second job. I can't help you. The guidelines are the guidelines for a reason.
Right.
Yeah.
Right. And your notice of assessment, line 150 income, was this. So based on your income, this is the child support. And and it's not paid, it's based on your gross. So it's just like, this is not what's going in my pocket. So how are you asking me to pay it? And sometimes I say, well, maybe you have to get another job. I don't know. I can't, create the
they have to deal with the guidelines are what they are, and they have to solve that.
Exactly.
I feel like we could talk about this forever. Maybe we'll have to have you back for another episode. But
I know.
Thank you so much for being a guest. This has been so much helpful information, and maybe we need to do a part 2 at some point.
I think we should do a part 2.
For sure. I'm happy to be here. Always, I can feel like I can talk to you guys forever. But thank you so much for having me. It was great.
Thank you for coming.
Thank you.
Thank you.
Thank you.
And thank you to our listeners for tuning in. I'm Leanne Townsend.
And I'm Jennifer Barkin.
And we'll see you next time.
Bye.